event is Privacy 2013. And now we're ready for the first panel on the state of privacy and technology implications for app developers. And Charles Belle is going to moderate this panel. And here comes the last panelist.
She wanted the corner. Shift. It's okay. And shift.
Oh, you don't want to sit next to me, huh, Laura?
Oh, no. I need my notes. I actually have to.
No, I want Jonathan next to me. There we go. Does everybody have water? Are we all okay? Okay, here we go. I think the mic's working. Okay, well, thank you very much. It's
Bread, drink. That one's mine.
You can take this
You
one.
all know that rule, right? If you're ever sitting at a table and you're not sure which drink is yours, if you put your hands down, this one forms a B for bread. This one forms a D for drink. So anytime, if you get nothing out of this privacy conference, you have now learned how to sit at a table with a whole lot of people and figure out which drink is yours. Bread, drink. And on that, I'm taking off.
Okay, well, this is our first panel. Thank you, everybody. This panel is the State of Privacy and Technology, Implication for App Developers. The purpose of this panel, just generally speaking, is to lay the context for the day. And we have a very, very, I won't say powerful panel right now, and I'm going to introduce them in just a second. That I'm actually quite honored to sit up here with all of these people. The way this panel will work is that we have questions that we've already kind of gone through. We're going to prompt, and we're going to talk about the privacy space in a variety of different areas. And then following that, you will be able to ask questions. So please keep your questions in mind in terms of later on. What we'll do is you can just raise your hand, and I'll give a heads up before we start that. One final point, I'm not sure if it was mentioned, it's just a kind of a logistics thing. We do have a website set up right now, institute.uchastings.edu. That it's a temporary website that we created just for this event, although we're going to hold it up for a few days or a few weeks after this. And it has a lot of information that many of the panelists today are going to be commenting on. In fact, I know Laura, for example, provided a lot of links and information, but they're up there. So when she references them and you want to know what she's talking about, please go to that website. And again, that's innovation.uchastings.edu. I think that should be it. Is that? Anybody confirm that? Oh, right. There we go. Thank you very much. Okay, so that's the information. You can also download a PDF of a lot of the links at the bottom of the page, I believe, as well. So everything's set. So without further ado, I would like to introduce our panel, beginning from that side over there. We have Laura Berger from the Federal Trade Commission. Laura is a senior attorney in the Division of Privacy and Identity Protection at the Federal Trade Commission. She enforces federal laws that protect consumer privacy. She's worked extensively on policy and enforcement involving standards such as Section 5 of the Federal Trade Commission Act and the Commission's safeguards and privacy rules under the Graham-Leach-Billy Act. Bliley Act. Sorry. Yeah. Morgan's over here correcting me. In addition, she was the author.
You shouldn't have to know that one.
Yeah, no, I just got tongue twisted with the three names. In addition, she was the author of the Commission's Safeguards Rule and has worked to develop educational materials to assist businesses to comply with that rule. Recently, her enforcement efforts have focused on privacy and security standards applicable to social media. Previously, Ms. Berger was an attorney with the Office of the General Counsel at the FTC. She received her BA in English from Tulane and a JD from the University of Michigan Law School. Next to Ms. Berger is Travis LeBlanc. Travis LeBlanc is the special assistant to the Attorney General of California. Is that correct? Special Assistant Attorney General of California, excuse me. In this capacity, he oversees the California Department of Justice's work on technology, high-tech crime, privacy, antitrust, human trafficking, and healthcare issues. He also advises Attorney General Kamala D. Harris on significant appellate and constitutional matters. From 2009 to 2011, Mr. LeBlanc served in the Obama administration as an attorney in the U.S. Department of Justice's Office of Legal Counsel, which advises the President, Attorney General, and General Counsels of executive branch agencies on the constitutionality and legality of the programs and activities of the United States government. There he worked on a diverse range of issues from executive privilege to federal health care reform to national security. He previously worked as an attorney at Williams & Connolly and Kecker Van Ness, where his practice concentrated on white-collar criminal defense and complex civil litigation. He clerked for the Honorable Stephen Reinhart on the United States Court of Appeals for the Ninth Circuit. He has an AB from Princeton University, an MPA from John F. Kennedy School of Government at Harvard University, a JD from Yale Law School, and an LLM in International Law from the University of Cambridge.
You're smarter than all.
Next to Mr. LeBlanc, we have Parker Higgins. Parker Higgins is an activist at the Electronic Frontier Foundation, specializing in issues at the intersection of freedom of speech and copyright, trademark, and patent law. He previously lived and worked in Berlin, Germany. Parker studied at the Gallatin, is that correct? Gallatin School of Individualized Study at New York University, where he developed a concentration of creativity, freedom of speech, and intellectual property. While at NYU, he also served on the Board of Students for Free Culture and as the president of its local chapter. Next to Mr. Higgins, we have Morgan Reed, the executive director of the Association for Competitive Technology. Morgan Reed is a widely known and respected expert on the government impact on technology and innovation. As ACT's executive director, Mr. Reed specializes in issues involving application development relating to privacy, intellectual property, competition, and small business innovation. Mr. Reed has authored and contributed to several white papers dealing with applications development in government, including a crash course on open source and a software developer's guide to the DMCA. He was part of the developer team for the Linux router project, Leaf, and remains an active Apple and iOS licensed developer. Next to Mr. Reed, we have Jonathan Nelson. Jonathan Nelson founded Hackers and Founders as a way to connect with startup geeks. Since then, it's grown into the largest community of early startups in Silicon Valley. Jonathan wants to hack Silicon Valley to make it suck less for new founders. Something he does now globally, too. Okay, so with that, we're going to jump straight into the questions. And so we're going to start a little bit big picture and then work our way down, just to give you guys a little bit of lead of where we're going. So we're going to start with policy first. And we're going to start with federal, so we'll kind of start at that end of the table with Laura. And regulation of personal privacy at the federal level is largely enforced by the Federal Trade Commission. As an agency, the FTC provides industry standards and tends to punish bad behavior. And generally, we hear about the FTC when it punishes bad behavior, but we want to start with what is the role of the FTC? How do you see the FTC in this space generally, and the structure with respect to consumers and developers?
Hi, everybody. Thank you very much to our organizers and to all of you guys who showed up today. I want to give, just as requested, a little general information about the FTC's role in the privacy space, and it would help me a ton to know who I'm talking to. And so I'd just like to see, if I could, a show of hands. How many of you guys are app developers? Great, love to see those good numbers. You guys, we spend a lot of time thinking about how to reach you guys and how to have some form of dialogue with you guys, because I suspect, as this next show of hands might reveal, this effort is much needed from us. How many of you guys have some familiarity with the FTC's role in privacy? That's impressive. That's great. And to the extent that overlaps with the app developers who raised their hands a minute ago, that's even better. I'm a staff attorney in the FTC's privacy division. I'm based here in San Francisco, actually, right down the street at 5th and Market. And as Charles mentioned, I did send quite a number of links, 8 links, of things that I think you could check out to get familiar with our role in the privacy space. One of the things, first and foremost, that's always interesting and gets people's attention is, of course, our law enforcement mission. We've had over 100 cases where we've brought cases or had settlements with companies of allegations that the companies violated the law because of their privacy-related conduct. And so let me just tell you what the basic standard is, that in many, many instances, when you read about one of our settlements with a company about privacy, the basic standard that we're enforcing is just a standard that prohibits unfair or deceptive acts or practices. So, you should be thinking about deception when you are looking at everything you say to your users about what your practices are and making sure that your practices line up with what you say. And unfairness in many ways is similar to that. An unfair practice is one that it causes or is likely to cause substantial injury to consumers and isn't outweighed by benefits to consumers or competition, and that consumers can't reasonably avoid. So what on earth does that mean? I mean, that's the legal standard. We have to worry about what that means. If we have concerns about your conduct, we have to make sure that we can establish that it meets the standard if we want to allege a law violation. But what does it mean? Again, it means that something's happening to consumers' information that's not what they expected. In the case of deception, it's not what they expected because it's not what you told them. And in the case of unfairness, it's maybe not what they expected because they just had no reason to know about it. So, we have alleged in one case against an app developer that the app was unfair because its default settings were more permissive than a consumer would expect and would cause the consumer to share more information than they expected to. And that was a file sharing app. So we do take a careful look at app developer practices from the user's perspective. So that's the touchstone of our law enforcement work in the privacy space we'll come back to. But we also do a tremendous amount in the policy area, really to try to reach out and have a dialogue with privacy advocates, with innovators like all of you, to figure out how we address, like, for example, in the mobile space, some of these monumental challenges of how on earth, when you have very limited attention, you're hoping to get any attention from a user, and how are you going to spend that limited attention span that you have to communicate effectively about privacy. So we try to have a big open policy dialogue with folks about that, and we host a lot of public forums, some of which I'll mention. And then, of course, we do lots of education, both for businesses and consumers. So at least half the links that I provided you guys are education pieces that we've done for app developers. A lot of that in those links can be found, you'll see, on the business.ftc.gov site. So some of the tips that we give businesses about, hey, if you want to stay on the right side of legal compliances and have best practices, here are some things to think about. I think we'll touch on some of those during our discussion. So thanks again for being here.
So building off that just a little bit, that's the federal side, but we have federal and state. So Travis, if you would mind kind of just maybe talking about the distinction and talking about what the state does and distinguishing that a little bit from the FTC a little bit.
Yeah, sure. Thank you very much for co-hosting this event with us today. As many of you just heard from the Attorney General, we in California are very proud to have so much of the technology that is changing the world headquartered right here in the state of California, emanating right here in the state. You know, I like to say that California is the technological engine that is combusting for the world right now. And today, we've focused on doing our outreach to make sure that we are reaching out to the community to inform the business community, the technology community, the app community about what privacy laws apply to them, but moreover, what are the best practices that you should aim for today? We are very good with dealing with lawyers. We do it regularly in the Attorney General's office. What we're trying to do, though, is realize that rather than having to reach a point where we have to issue a subpoena or file an enforcement action, we can do outreach on the front end to avoid problems that lead towards an enforcement action on the back end. And that's really what our goal is. As the Attorney General mentioned, we have a privacy enforcement and protection unit that she created in 2012, which enforces federal and state privacy laws. That's often a misconception that a lot of people have, that the federal government does its thing and then the states do their thing. In reality, we have a lot of overlapping authority. So a lot of the same issues that Laura talks about as violating federal law either also violate a state law, or we in the state have the ability to enforce federal law. And some of the more famous ones, just to give an example related to privacy and apps in particular, something called the Children's Online Privacy Protection Act, which many of you may have heard of, which generally speaking, this is just very generally, requires child-directed websites where, websites directed towards children under the age of 13 to have a privacy policy, and requires generally that general websites that collect information from children under the age of 13 have parental consent to do so. We in the state are allowed to enforce that federal law as well. We also enforce some other privacy laws. So I just mentioned that at the outset. In addition to having sort of jurisdiction over the enforcement of privacy laws, we also have jurisdiction over the enforcement of criminal law in the state of California. And the Attorney General mentioned that she created an e-crime unit in 2011. Our e-crime unit prosecutes identity theft crimes. Now, I tell you that, as well as high-tech crimes involving allegations of hacking and network intrusions and online auction fraud and other kinds of high-tech crime. But I mention that to you because that really is the criminal side of privacy that we're all really talking about today. What happens when an unauthorized third party obtains access to personal data that a company has is they often use that for some nefarious purpose. Whether that nefarious purpose is a cyber attack or whether that nefarious purpose is to steal their identity and then open up financial records for them, the reality is there's a real financial and physical safety risk to people when their personal data is out there. And so in thinking about privacy from the criminal side, we have an e-crime unit that's there. But we spend a lot of our time really thinking about myths and trying to debunk those in the business community as well as in the population more generally. And you heard the Attorney General talk about some of those today, but I want to talk about some of the other ones, at least from the business side, because I think it's useful to a lot of app developers to understand it. When most people hear about the California Attorney General's office doing something, they think it only applies to California and it only applies to the companies that are based in California. But that's a bit of a myth that's out there, because anytime a company does business with a Californian, it doesn't matter whether or not you're actually physically in California, you are subjecting yourself to the jurisdiction of the state of California. And that's true of any state in the country. That's not some specific California law. That's just a generally recognized thing. So when you think about the beauty of an app and you realize that, 10 people or 2 people can do business with thousands or millions of people across the country at any given time, you realize just how many jurisdictions you're interacting with. I found something very interesting that I just learned this week, which is Twitter. During the so-called Arab Spring in 2011, I think it was, Twitter, which is largely considered responsible for the dissemination of a lot of information that led to some of those results, only had 40 employees. 40 employees at that time. That's all Twitter had. And look at the impact that they were able to have on the world with 40 people. It has never been in the history of the world that we've had so few people in a remote part of the world able to do so much and interact and change the world as we know it. And that innovation is the beauty that we see, but it also comes with complications when it comes to interacting with law. So the first thing that I want to do is talk about the myth of sort of you're not working in California. The second myth that I think is often there is that the traditional rules that apply to brick and mortar stores don't necessarily apply to online companies, and vice versa. That is, that the rules that apply to online companies don't necessarily apply to brick and mortar companies. But the reality is we're seeing the merging of our offline and online worlds. We're seeing the merging of the business models, our traditional business models. When you have something like, a new app that helps you hail a taxi cab, suddenly you're seeing the merger between 2 different business models. We generally, when it comes to privacy, take the premise that the same privacy rules that apply to the brick and mortar world, generally speaking, apply to the online world, and vice versa. That when we're talking about, privacy in mobile apps, we're not just talking about, 2 hoodie-wearing app developers in the South of Market area or in Palo Alto. What we're talking about is anyone that wants to do business online. And if that does not matter whether you're an airline that decides to go online or whether you are a more traditional tech company. And then the third myth that I just wanted to raise is, and this is one that the Attorney General spoke about just a minute ago, was that privacy and innovation are somehow incompatible. We in California have some of the strongest privacy laws, if not the strongest privacy laws in the country, yet we're also the center of innovation. What we have shown in this state is that you can do privacy and you can do innovation together. And that innovation sometimes comes in the form of laws, but moreover, the innovation we're talking about comes in the form of the technology that's there. We are fundamentally looking for the balance between those 2. And so we're excited that all of you are here with us today, and I certainly look forward to the panel discussion that we're going to have, as well as the other panels later on throughout the day.
What I'd like to do is kind of take that and actually segue from what we talked about, the split in jurisdiction, which you touched upon several times and yet overlapping. And I'm going to pick up on something that's very specific to the AG in terms of the mobile platform. I want to talk about that, but I also want to broaden that then to the rest of the panel. So I'll let you talk about the AG's, the recent publication in January and the agreement with the platforms to go into more detail. But then after that, what I'd like to do is hear from kind of the different perspectives on how they're seeing that agreement play out in the consumer side, with Parker, with Morgan talking about kind of a national industry level, what does it mean with one state driving these kinds of conversations, and then from an individual developer level, just to give us a little bit of head up.
Sure. In 2011, the Attorney General took office, and we were examining the privacy laws throughout the state of California. At that time, there happened to be a series in the Wall Street Journal, I think it's called What Do They Know, which looked at privacy in mobile apps. And it found that less than 50% of mobile apps, again in 2011, had privacy policies. Less than 50%. And the reason it focused on privacy policies was because in the view of the journal at the time, privacy policy is the first thing you could do to start to think about privacy. Just having a privacy policy, just the first step. And if there weren't privacy policies, then what were going on with mobile apps? And then there were a whole series of incidents involving apps that were taking contacts or that were obtaining GPS location information, et cetera, without informing the user. And in looking at the California law, we realized there's something called the California Online Privacy Protection Act, which was actually passed in 2003, but that requires any commercial operator of a website or online service like a mobile app to conspicuously post a privacy policy if it collects personally identifiable information from any Californian. Now, in my experience, that is virtually every app. Not every app, but it's the vast majority of apps that are out there. At least if you're collecting it from a Californian, then you need to have a privacy policy. And of course, California is the 9th largest economy in the world. We have 38 million people. Nearly every app that's put into, whether it's the Apple App Store or Google, then it was the Android market, now Play, or any other platform, is likely to do business with some Californian. So we decided to reach out to the platforms, Amazon, Apple, Google, Hewlett-Packard, Microsoft, and Research in Motion, to work with them to see what they could do to help us improve compliance with California's Online Privacy Protection Act. And over the course of 6 months of negotiations with them, we arrived at an agreement in February of 2012 that would, where the platforms recognize that whenever an app is doing business in a jurisdiction that requires them to have a privacy policy, then the app is required to have a privacy policy. And as many of you know probably already, when you post your app into Apple's App Store, for example, or Google, you agree to comply with all the terms of service require you to agree to comply with all applicable laws. But the more important innovation of the agreement was that the platforms were going to include a link to the privacy policy for the app in the app platform store. That is, rather than having to go on what I used to call a treasure hunt, once you get into an app to find a privacy policy, if it had one, sometimes it's in the settings section, sometimes it's on the first screen, sometimes the whole privacy policy is in there, sometimes you have to go to the website to figure out whether that applies to the privacy policy for the app. And after all of this, you have to purchase the app first, and have any of you ever tried to return an app? You might, it's not so easy. So you purchase it, you're suddenly sharing your information, and then you can figure out what its privacy practices are. No, we were able to change that, build the privacy into the design of the platform, and to get them to agree to post a link to the privacy policy right in the platform store. And from an app developer perspective, this is the beauty of the agreement. We were able to get them to give up some of their space within the platform, their real estate, to post this link to a privacy policy. As you know, as app developers, when you're in that platform store, you don't have a lot of room to market your product. If suddenly you had to post a whole privacy policy in there, you wouldn't have any ability to talk about what's the actual app that you have there. By getting the platforms to put it in their real estate, we were able to preserve that valuable space for the apps themselves. And so that agreement went into effect. It took about 6 months for the platforms to all implement it. And what I'm proud to say is that within a year of the announcement of our agreement, we saw compliance go up dramatically with California's Online Privacy Protection Act. That is, we're seeing that approximately 75% to 80%, at least of the top free apps, top 100 free apps in the relevant stores, have privacy policies. 75 to 80%, when a year earlier, it was less than 50%. I would assure you that if we had issued a subpoena or filed an enforcement action against one company, we would not have doubled compliance with the law. And we did all of that without taking any formal authority. So we're very proud of the agreement and have received a lot of good feedback about it so far, and look forward to hearing what others think about it.
Well, on that note, let's jump a little bit to the industry side, shall we? And Lauren, why don't you talk about that?
So that was a whole lot of stick. That was a lot of stick. Wow, that was a lot of stick. You can get sued, flayed, baked alive, thrown in jail, a lot of stick. But I'm here to talk to you about something that I hope most of you like, which is the idea of making money with your application. Being successful. Finding a way to reach customers. Amazing. So you all understand that you're part of this mobile apps economy and that it represents the fastest growing adoption of technology in the history of mankind. The history of mankind. Faster than fire, faster than the stove, faster than electricity, faster than anything ever. To borrow from Ghostbusters, that's a lot of registered voters. That's a lot of potential customers for you. But you know, at 99 cents, those applications aren't particularly going to make you fantastically wealthy. They're not going to grow you into a company that can buy this space and populate it with developers. You've got to find a way to have the customers want to use your product. And in that regard, I'm going to talk about the carrot part of this, and there's two reasons why people choose to purchase or use a product. And that's brand and price, right? Can I trust you is the question that's asked around brand. When we look at the brands that we buy on a daily basis, a huge part of why we buy them is because we trust them. So the implications around privacy is not that we're sneaking around trying to steal people's stuff, is that we need to understand that we need the customer to trust them so they'll use our stuff, so that they'll buy our product, so that they'll continue to tweet, so they'll continue to use whatever social networking tool we are designing to take over the world so that we can occupy this kind of space in today's market. So as you look at your app that you're developing, what I'm finding is a big problem with this that we're having is a bit of a language problem. So you heard about personally identifiable information, COPPA, what's in it, et cetera, et cetera. How many of you are building mobile applications and have analytics as part of your feature set? All right. How many of you don't know if you're using analytics as part of your feature set? Okay, that's good and unusual, and I'm not entirely sure it's truthful. How many of you are using other SDKs that you're acquiring either directly for pay or for free as part of your development process? Unity, Appcelerator, any of those? Okay? So how many of you have actually read the agreement that you signed with Appcelerator? I know, what, two? Well, the woman in the back, can you tell me what it says on that first paragraph of the Appcelerator agreement? No, there's a reason why I picked Appcellators, and Laura knows this. Oh, Laura and I did a presentation at South by where I said, I agreed to what now? Because Appcelerator's front end of their agreement says, what is it? This is a long agreement of legalese that nobody in their right mind would read without being brain damaged or jailed for life. We can't change it. Rules are rules, so we're making it look really boring, complex, and overly important by using small fonts and capitalized words here and there. So you remember that stuff you heard about compliance and making sure we have all that legalese covered? Well, I'm pretty much sure none of you actually read Appcelerator's. This is Appcelerator Explorer License Agreement for Appcelerator Titanium Studio. I guarantee some of you in this room are in fact using Appcelerator's tools. And I'm not picking on an Appcelerator. I'm saying as a developer, you need to understand the language of reaching trust, of reaching brand, of being the one people say. Because, you know, a few months ago there was a study that Pew did that said 97% of people care about privacy. BS. 97% of people are aspirationally caring about privacy. That number doesn't mean anything to me. The number that does mean something to me and should mean something to you was 54%. 54%, 57% 57, see, we've all done this too many times. 57% of users said they did not download or deleted an app because of privacy considerations. That's a number I can sink my teeth into. That's a carrot number. How do I not be part of that 57%? How do I be the 43% that people say, I trust you? I want your app on it. I want to share my contacts with you, from Kamala Harris, from A.G. Harris's earlier comment. Or I am okay with you having my IP address. You all know, right, because we're going to be ending up bootstrapping COPPA. IP address, personally identifiable information or not? Show of hands. What do you think? Is it IP? One thumb, couple of hands. Guess what? In the law, probably going to be. All right, it already is with our European friends. IP address, if you collect an IP address on the user, any kind of unique identifier, an IP address, IMEA number, MAC address, you need to know that you have essentially collected something that a lot of governments consider to be personally identifiable, and therefore you need to comply with CalAPA and with the federal regulations and make sure that you are notifying your customer that they're going to do it. But we all know the customer's not going to read that. But what he does need to know is, can I trust you? So really, in the end of the day, you need to do a couple of things. You need to know what the heck you're actually collecting. You need to know what that agreement had with Accelerator. Later today, we'll talk to Privacy Choice, and I know Trustee is here as well. They have tools that help you figure out what your app is actually doing. Although, frankly, all of you should be able to set it up on a proxy server and take a look. I highly recommend you do it for some of your apps that you know. You'd be blown away at some of the sharing that goes on. And it's not evil, it's that you don't know.
Yeah.
And
Can I chime in with one of my stick points just to really cement what Morgan is saying here? So one of the documents I shared a link to is the Kids App Report, the second one that we did in 2012, and in that we looked at 400 apps that are directed to kids, 200 in Android, 200 in iOS, and we found that 57% of those apps were transmitting some personal information, collecting and transmitting some personal information, most commonly, overwhelmingly most commonly, UDID. But only 5% of that was going back to the developer. The rest of it was going to somebody, probably like the ad network, somebody they got software from, and probably the developer did not know it.
But I want to make clear, there's nothing evil about ad networks. There's nothing evil about what you're doing. Don't be sneaky, right? Know what your app is collecting. Make sure that you find a way to be able to, if a user wants to know it, that you can. Because, back to basic carrot, right? There's 3 reasons you start a company. Three, yeah. 1, go public, right? 2, leave it to your kids. Or 3, be acquired, right? I mean, we all dream of IPO. But the reality is a lot of us are probably going to end up being acquired if we're successful at all. Well, when you walk into that meeting to figure out how much the net worth of that product that you've put your blood, sweat, and tears in, you want to walk up with something that looks like this and says, here's all of our privacy stuff. Now let's talk about how awesome my app is. You want privacy off the table. You don't want their compliance lawyers to come back to you and say, yeah, I'm taking $1 million off the top because the information that you collected, you don't have an agreement with your customers that covers it, and therefore 7 million of your acquired eyeballs, I can't monetize. Oh, crap. I just took money away from my kids, my investors. Don't do that. Have that privacy folder. Have some clue. Scope out a couple of hours and go through your stuff. Run a proxy. Know what you're doing. Because once you get that, I want you all not to spend your time being privacy experts. That's my 7th level of hell. Your job is to create awesome applications that change the world. And that brings me really quickly to the last part of this, which is I'm going to give you a secret on where you can make more money, hopefully, fingers crossed, than 99 cents. Health, financial services, enterprise, education. Well, you know what all 4 of those have in common? They're a little more squeaky about things like privacy and what you're collecting. People want to know if you're gathering information about their bank account. People want to know if you're collecting information on their kids. People want to know if you know what their medical conditions are. So if you want to move your app outside of the 99-cent ad network space or want to explore those opportunities, get right on privacy. Because there's an enormous carrot to not being in the 57%.
So I want to segue on that. Actually, it's good to talk about developers. So we've heard a little bit from the government side, we've heard from the money side, monetization side. Let's talk about developers for just a second and their take on this approach and what they're seeing both in terms of the agreements that are coming down with the AG's office, the work the FTC is doing, and even monetizing as well.
I am so confused and really kind of ambivalent because so I've been coding since I was 7. I actually spent 20 years working in clinical healthcare as an ER and trauma nurse, and so I'm really profoundly sensitive to like privacy issues and stuff like that. I went back to school for software engineering, and then 5 years ago I moved to this town to try and seek my fame and fortune and take 10 years to build a startup. And along the way I started hanging out in a bar with a bunch of other entrepreneurs, and the entrepreneur group kind of grew into a thing. We now have 30 other Hackers and Founders chapters around the world and a global reach of 35,000 members. We have 9,000 members here in Silicon Valley. I generally am not a legal, political kind of animal. I generally just want to build things because it's awesome. Yes. And I see ones and zeros, and I see I want to move them from one place to the other, and ones and zeros in data and information flows. And sometimes when there's an obstruction to where this data flows, I just stop and I think, well, I'm a hacker, which doesn't mean that I actually break into banks or anything like that. That just means I try to think outside of the box and creatively problem solve. But as part of being a hacker and trying to think outside the box, I'm trying to think of how do I actually build my company? I see this shiny new technology. Oh, look, I have a 4-propeller quadricopter and I can steer it with my iPhone. This is really cool. Maybe it can bring me a burrito. Maybe I can build a business like that. Maybe I can bring, hey, maybe people would pay me to have like burrito delivery on a quadricopter. I need this, I need a push to buy. And seriously, this was like a competition a few months ago in town. It was like Burrito Copter. It's coming. It's just going to take another 1.5 years for the batteries to actually get big enough. I'm so excited! I want burritos brought by helicopters. But this is what I think about all of the time. And then all of a sudden, I hear weird things like a border and jurisdiction has influence on the internet. And then I'm like, what? So what, SOPA? What? Why are you breaking DNS? What? And then a bunch of other people start emailing me, and we organize a SOPA protest in San Francisco, and a lot of other things happen. And then I start thinking about policy stuff, and I start thinking, this is weird. Like, rules defining a state, and I'm mostly kind of talking about how a developer thinks, but like, the thought of an international boundary or even a state boundary when it actually comes to data and the internet is really silly to me. It seems very archaic. I deal with people from all over the globe, and things like immigration, which stop one person from moving from one part of the world to the other part of the world. What? Why? Like, I see these blockages and I think, why? But then on the privacy side, like, I don't use Facebook. They creep me out. Like, I have it. I don't with the Twitter. Why? Because I computer, I don't necessarily broadcast. I don't feel it necessary. I don't like it. No, I'm not going to. You can't force me. But I'm a fairly social person. I have a social network, which means we hang out in a bar and we have drinks together, and my mailing list is 9,000 people long. I've had beer with a lot of people. I'm very social, but I don't really, as a consumer, want everybody to know where I am having beer. Just because I'm paranoid doesn't mean that there are companies out there that have a lot of great information on me. And so, for instance, my wallet actually has a Faraday cage on the outside of it. There's like a wire mesh that prevents, magnetic signals from getting it. Like, no one can read the chips on my credit cards. No, but really. Like, privacy is a big thing for me. At the same time, it's really weird to actually think about rules in terms of privacy. I always want to do the best thing for my customers, and I want to do what's right for them, but ooh, crap, I need to have a privacy policy. I'm going to copy and paste from accelerators. Shit, go. But this is the reality of most of us all of the time. And then all of a sudden things explode in my startup, and maybe ICANN has TechCrunch coverage, and maybe that goes viral, and maybe there's a really cute cat picture on my website that everybody starts to like. And all of a sudden, billions of people are using it and dancing around like horses or something. I don't know. But this is kind of the world that I live in. And so what I would actually ask from people in policy and people in the legal departments is like, I really do want to do the right thing. Just, can you explain it to me like I'm 5?
Yeah.
And I really appreciate it. And a lot of times, like when I think privacy policy, I just think TLDR. Too long, didn't read. Next, boom. When I look at terms of service, I think too long, didn't read. There was a story a few weeks ago. It was someone had actually buried, if you read this and email me, I'll send you $1,000. Yeah. And it took them like 6 months to actually cash in. It was a pretty major company. Do you guys remember which one that was? I don't know. I read it on the internet, so it must be true. So it's stuff like that, and I don't know a good way around this. I mean, I think what you guys are doing is amazing and awesome, because privacy is awesome. At the same time, the thing that creeps me out isn't when an app says, hey, can we access your contacts? Sure. Hey, can I access your location? Sure. But what creeps me out is it actually takes me a couple of years to figure out what some of these companies are doing in terms of business model. And all of a sudden they have all of this data, and data flows, and ones and zeros move from one place to the other. And I'm really ambivalent about that. I love what it brings me, but it also really scares me because Big Brother is no longer government, Big Brother is companies. But I don't know. I'm really kind of ambivalent about this whole thing.
I think
the
actually
five-year-old, yeah. We'll go
on
to
that
you.
note, because the thing is, because I also want to kind of wrap up the policy section as well, and I think you ended it well in the sense of, yes, you're developers, but you're consumers as well.
That's right.
You're on both sides of the coin, and so that gets us perfectly to Parker, where Parker could talk a little bit about, and then we'll move off of policy. Actually, we'll do a quick wrap up about policy.
right between.
Yeah, you're right in the middle. Yeah. Well, what about consumers, the individuals? What are they thinking about policy? There's a lot of discussion. It's already been mentioned about the surveys. So how can you kind of speak for the rest of us?
Yeah, well, so I think that actually some of what you were saying, Jonathan, links back to some of what the Attorney General was saying this morning, that the best approach isn't necessarily legislating in every, or regulating in every situation that you can imagine, making sure that the companies do the compromises that you think are best. The approach is giving consumers the information they need to make those decisions themselves. And I think that you can decide whether or not you want to use Facebook or Twitter, and you can decide on a lot of these apps whether you give your contact list or give your location. The problems arise when you can't decide, or when you're not presented with that decision, and as a consumer and as a user, you think about things like privacy policies. And privacy policies are, as UI, they are a disaster, and as UX, they're even worse, right? So you can get compliance with having a privacy policy, but when it has language that nobody knows, it doesn't really do its job of empowering the user to make these decisions about what information it is that they want to share and what they expect to get back from that. And I think that answering those questions goes beyond just setting up a good privacy policy, and it goes really down into the design of the app. And we got kind of a nod to privacy by design in terms of putting it in the App Store, but really it can go so much deeper with app developers themselves, and I think you get these confusing outcomes where people, where it, it feels tacked on or it feels weird when in fact it is tacked on. But if, right, it's not a surprise that it feels like these privacy rules don't make sense if you think of them as privacy rules. But if you consider, okay, I'm going to make a minimum viable product of this app, what does that require? Okay, it needs to be able to take input, not break, and it needs to, and one of the things maybe is that it needs to not surprise the user when they're using it. The user can't find out later, oh my God, it was collecting that. And so minimizing that surprise, I've heard described as a surprise minimization framework. Do you know who so yeah, using that surprise minimization framework that's described in the guidelines here, you get to a situation where it doesn't feel strange. The data may flow, but people know what data is being collected, and it's not more than they'd expect. And I think when you do that, by all means, you should still have a privacy policy, and you do need to, when you're making an app, you need to bring it into compliance with users' expectations, but you also need to make it work for lawyers. You want to cover all your bases. But when you do that, when you make good privacy decisions from the beginning and you minimize the data that you collect to what you really need, then users may not feel like they have to consult the privacy policy and read this dense legalese before they can build that trust. Because, spoiler alert, they will not do that. And so if they feel like they have to read through 3, 10, 15 pages of legalese in different capital letters, then you've lost. You won't get that trust. But if you feel when you're using it like you know what it's doing, and in fact you do, and there aren't front page stories about how you didn't know what it was doing, then you're doing all right. And I just want to, one more point is that I think previously we had this paradigm where the system would be to collect as much information as you possibly could because you didn't know what would monetize. And I think that, Morgan, you spoke to one reason why that's not working anymore, because now at acquisition time, if you collected it the wrong way or if you collected too much, then this could actually, there's a dollars and cents consequence. But I think there are a lot of ways in which, especially in the last year and a half, this has changed, where it used to be that the cost of collecting and storing was zero and the benefits were non-zero and positive. And so you would do it anyway. And now I think either through stick reasons or through carrot reasons, that's not the case anymore. You need to be, as developers, you need to be a little more thoughtful up front about what you're collecting, because there can be a cost to it. But then once you've gone through that thought process, and once you know what's happening, then it's not like you can't collect that data. It's just you have to do it thoughtfully.
So what I'd like to do is, because I want to move us from policy changing. Second, kind of being transparent as much as possible to build up that brand, and also to stay on the good side of privacy from the regulator side. But being transparent can go a very long way towards working both with consumers and working with government, because everyone kind of knows where you stand, and then it's a little bit easier to talk about from there. And then finally, and I'm going to do a little bit of Jonathan here, I'm going to read into this a little bit, kind of a do unto others. Don't just think about yourself as a developer. Don't just think about yourself in terms of monetization. Don't just think about worrying about the stick. Think about yourself as a consumer as well. Think about you're building a tool. What tools do you want? What tools are going to go out there? So I think from a policy, kind of general speaking, kind of 100,000-foot level, those are the kind of 3 takeaways that I've kind of grabbed onto for the last conversation. And we can kind of move more into some specific issues that maybe people are addressing, specifically with consumer-oriented challenges. And that's kind of how I've titled it. But just to give a little bit of some context here. So as Morgan, I think, touched upon this, consumer access to, computing devices and products, it's increasing rapidly. It's not even, when we say mobile devices now, we're not even just talking about the phone. We're going into clothes for that matter. We can talk about wearable tech and what that's going to mean. It's a whole other conversation. So this has raised a lot of new issues. And the system that we have, maybe the regulatory system that we had before, wasn't always set up for this. No one's fault. It's just times have changed. So one of the key things that we see, and I want to talk about this a little bit because we see this when you do read the privacy policy statements, you'll see this quite often because I do read them, is personal identifiable information. And we don't collect that, or we will delete that. Delete that. But there really isn't kind of a legal definition about PII. Last summer, I know we had someone break down all the definitions of PII. There are over 50 big ones, just because every state has their own, and then local jurisdictions sometimes have them. There are certain federal laws. So it's basically a very undefined term that's used very often in a way that people can think is common. So what does this mean for companies? And this is the question that will be posed to the panel. Is it a term that they need to define within their policies? Is there a concept around PII that we can feel safe with when they're using that? Or is it something they should just be very clear about and just say, this is how we're defining it, we're moving on from there? Start with Morgan.
Well, two things. All of you have your mobile devices with you. I want you to get them out of your pocket, because I'm going to take it slightly from the theoretical to the practical, and this gets right to the consumer issue. While everybody's digging them out, this is my analogy I've come up with. I haven't refined it, but you're all familiar with TiVo, right? The TiVo Remote, really simple, very clear, prize-winning remote, amazing remote. And you're all familiar with the Sony or Samsung remote that like one person in the house knows how to operate and nobody has a clue what those buttons do on the lower third of the remote. Well, the problem we have with privacy policies is that the privacy policy we present to consumers is like the Sony remote or the Samsung remote. No one knows how to use it. Nobody knows what it means. So the problem we have is, how do we get to a TiVo remote? What are the 6 things that you need to know? And you know, Ann Toth, who used to be at Google, actually had an article she just wrote saying I was wrong about privacy. And what was very interesting in her, though, is she got to the core problem that Jonathan and I have out of this. And that is, she quotes from the movie Amadeus. And in the movie Amadeus, Mozart is approached by the emperor, and the emperor says, I loved your symphony, but it had too many notes. And Mozart turns to the emperor and says, very well, sir, which notes do I cut? So within the privacy context, as you just heard, there are 50 states. There are essentially everything is possibly actionable by a privacy regulation in terms of being PII, especially once we get to Europe. So which notes do we cut? How do we make the TiVo remote and not the Samsung remote when it comes to privacy policies? So working with the Federal Trade Commission and the AG's office through the NTIA multi-stakeholder process, is a lot of acronyms. So I'm going to get a really short one. Pull out your phone and look at bit.ly/PRIDASH. I assume everybody here knows what Bit.ly is. If not, bit.ly. Now this is an attempt that has been collaborative with the Federal Trade Commission's report on what it looks like. It is by no means finished. It is by no means done, but it's an HTML5 app that runs on every device that gives a look at how this might happen. What does a TiVo remote look like in this space? Bit.ly, you've seen it before. bit.ly/PRIDASH. You can also go to, I know the other Bit.ly for it, but PRIDASH, PRIDASH. Is it not coming up?
It might be in the connection.
Oh, okay. For those who can pull it up, it's an experimentation on this layer of how do we do a better job of communicating with users. Those are all touchable, right? We came at it from the approach that you all should from a developer perspective, which is touchability, glanceability are 2 key elements to this. But you see the problem, right? The mobile user is a one-eyed, one-thumbed monster. They're walking down the street, they're downloading an app, they're not paying attention. So how do we grab them? The other element that you all need to think about from a consumer perspective, and how do we do this, is data isolation. We have, later on, I highly recommend, I'll salt a little bit here, that you stick around. I think somebody from Microsoft is here who can talk a little bit about privacy by design and some of that, because I don't know if any of you guys thought about it, but when Connect went into the house, they put a camera in every freaking person's household in the world, and it was looking at you. Holy crap. I mean, think about the privacy implications. We're talking about this. There's a spy camera in your house. So Microsoft really spent some time on saying, how do we deal with those implications? So privacy by design, which you just mentioned, is something that will be brought up in a later panel. But more functionally, how do you inform the consumers of what you're doing? So data isolation, Apple, other companies are doing more to minimize, right? If location is turned off by the user, the developer gets a null set. I don't get anything back. I didn't collect anything. I didn't violate their privacy because they had it off. So as a developer, you need to make sure that you're abiding by and working with those data isolation elements that are on these platforms. Because ultimately, we need to get to a consumer that can look at a Thetivo Remote style design on privacy, understand what they're looking at, and move on to your app. Because as Amadeus said, which notes do we remove otherwise? And until we know what notes we can remove, we will not be able to deliver the kind of transparency that everyone here has been talking about in a way that consumers will actually absorb. So I think your question about the consumer access to this information, we are facing some conundrums, and we don't have the answers, because we have to ask the regulators, which note do we remove?
I don't know if any of the government officials have any thoughts on that, just because of the regulations that we are talking about. They're coming from your offices primarily, efforts maybe to try to create a more cohesive, maybe, or even industry standard.
So there has been a lot of effort recently. I gotta say, I cannot give, as a lawyer, I can't give general advice on here's how you write your privacy policy. You start with the facts. I can't work with anything abstract and say, oh yeah, and this is gonna fit you too. You need to start with the facts and know what you're doing before you can even begin to write an appropriate privacy policy. But alongside all of that, there has been a tremendous effort and a lot of really smart people coming together to try to say, and once you know your practices, here are some effective communications tools to convey them to users. And so, yeah, I mean, we think, we've been supportive and participating in this effort to help develop, for example, some uniform icons that consumers will more easily and readily understand, like in the mobile space, to communicate about privacy.
And I would add to that, you all, when you came in today, should have received a copy of Privacy on the Go. This is a report that we put out in January of this year that is designed primarily for app developers, not lawyers. So much of what we put out is written for lawyers, but not this. This is written to provide a founder of a company, someone who's just starting to think about privacy, with a toolkit, a sort of a step-by-step instructions on what you should do to begin to approach privacy, right? It asks simple questions like, ask what kinds of personal data you collect. And we can debate along the margins about, the extent to which any particular data source is actually personally identifiable information. But there's some personal data that we can all agree on. A credit card number, an email address, a social security number, right? There are certain things that we can agree on. Now everyone generally agrees on geolocation, on contacts. There's just certain things that are there. Look at those, assess them. Figure out whether or not you need to collect all of that, right? We just heard about the idea of over-collecting, right? If you don't need it, then don't collect it. Stop collecting it. And then figure out how to be transparent about your process. Now, one part of transparency is about having the privacy policy. That's one part. But another part is about the user experience and figuring out a way to inform the user in a way that the user will understand what your practices are. Now, that may come with just-in-time notification with a little pop-up that says, do you want to share your contacts? But let's keep in perspective. That's a relatively recent phenomenon. That was not on the smartphone 3 years ago. Right, that's relatively recent to have sort of this just-in-time notification that's popping up for the vast majority of apps. So I highly encourage you to take a look at the report. If you follow the report, there's no guarantee that you are, 100%, compliant. And you can say, okay, I'm good to go. I can't say that it's a safeguard. But what I can assure you of is it'll get you 85% of the way there. Right? The technology is changing all the time. So it's impossible for a report that's written in January of 2013 to predict, I hate to say this, what the world is going to look like in January of 2014. We're seeing so much change so quickly. But I do hope that as you look through it, it's helpful to you and that you can use it as a guide in developing your app and your privacy practices.
So just one thought. As a consumer, I love this. Again, I'm also conflicted. Under these guidelines, Google would not have happened. Google's accidental monetization strategy, their strategy was, I want to build a search engine that doesn't suck. There's 6 others, they all kind of suck, so let me try to build it better. And they said, okay, after we do this, we're going to sell an appliance to enterprise, and they're going to buy it because enterprise search sucks. And 5 years into their business, they were going to go back to another VC and say, well, I might need a round. They ended up buying this little company called Applied Semantics, which some friends of mine started, some nerds from Caltech. And it turns out that their most valuable asset was the huge trove of people's personal information. And with Applied Semantics kind of matching algorithms, they could match essentially ad recommendations alongside of what people were searching for. That was a complete accident. And so when I build something, I just kind of embrace the fact that what I'm building might end up having really cool unintended consequences and might not have unintended consequences. And I love the fact that Google exists. I'm so glad I'm not stuck with Alta Vista. At the same time,
Alta Vista.
InfoSeek, yes. And I'm actually rooting for Blecko. Hi, Greg. Greg's actually building a search engine because he actually thinks that search still sucks. And they've built some amazing technology. But like being deliberate about what I collect is so weird. And a lot of times I just want to, for instance, build like, I just need to have like a web component to my mobile app. And what is mobile app anyway? I have a Surface. Is that a mobile app? I don't know. It's a Surface Pro. I carry it around with me. Is it a tablet? Is it a laptop? I'm so confused. But it is what it is. But I'm actually using Apache web server on the back end, and just kind of by default, it actually records people's IP addresses as they actually make a request. I don't ever really think about that because I use Google Analytics, and I don't necessarily look at their IP address. But like, is that a personally identifiable information? And now do I actually have to say to people, I know who you are. And so I like the fact that we're having this discussion, but as a developer, I'm like, holy crap, I just told a lady from the FTCs that I'm collecting information that I don't know about. And
But I just told you that 50 some odd percent, nearly 60% of the apps we looked at were passing along information they didn't know about. So you've got a lot of cover for that.
I mean,
got a lot of company.
with respect to Google or any other ones, you know, the laws that we're talking about and the general regulatory regime that we've been talking about have been on the books for over 10 years. I don't think there are any of them that are really new.
Don't be deceptive, tell the truth to consumers is what we've been doing for over 100 years. Privacy is just no different. You know, the thing that concerns me that you're saying is you're like, we have stuff happening on the back end that we don't think about. Well, you have to, because it's your product, and we will hold you responsible for your product.
so there's a lot of the beauty of, and I agree with you. At the same time, I'm terrified of you. Yep. Because, for instance, I need to know what product I'm using. So for instance, maybe I don't set up my own server. Maybe I just pay Heroku to actually handle all of my web hosting. So I just unload my code on them, and oh my God, it's so nice. I never have to think about scaling again. But all of a sudden, I'm using Heroku's software on Heroku's servers, which run on Amazon's infrastructure, which runs on somebody else's hardware. There are so many different layers, and the point of my using these other services is so that I don't have to think about them. And so,
But, you know, there's some tension there, even from your perspective. You're saying, hey, information is the holy grail. It's what made Google what it is. It's your most valuable asset. Don't you want to know what's happening with it? Like, don't you want to take reasonable due diligence so that you have some idea of what's happening with it and you can speak accurately about that?
What I want is I want to not have a 500 server error page.
Right.
And that's really, I'm just like, hey, I wonder if, oh crap, I pushed code that breaks the server build. Damn it. I should have written a few more tests. I know I should always write tests. And now,
No, just publish. You know.
What I really want is, I really want to pay somebody $5 a month to actually have privacy as a service. Just tell me what information I'm collecting and keep me in compliance. Like if someone, has anyone built that startup?
Well,
Trustee. Actually, I think there's somebody here from Trustee. Trustee does some of that stuff.
but I do think, I think that when you,
Customer.
Yeah. I don't think it's $5. That's the problem. I'm sure Chris is watching us on webcast, but yeah.
the $5 a month service, it can't be integrated at the design level if it's
Right.
that. And you don't want privacy as a service that you tack on later. You want this to be, and I think to get more straight to the point, the fact that there are other layers involved, and it does make it so much easier to be using Heroku, which uses Amazon, which uses which colos, or that to me seems like more incentive to be careful up front with what information you're collecting and passing on, because Heroku or Amazon or whoever it is downstream or upstream from you, they could have a problem, and if you were the one who's facing the user and it's your collection that ended up spilling, even if it was someone else's fault, that could be, even not even talking about the regulators here. If that ends up being a news story, you're in trouble, and that doesn't, and that's a reason. It does require a bit of thought.
But Parker, now you're mixing this is a problem we have from the developer perspective. You're now mixing collection with data leakage, and that's a huge part of this, right? Collection is one thing, but what gets you a news story is what you said, and that's when it leaks. Somebody leaves a laptop, somebody leaves a hack open. That was the example you just gave.
You don't leak unless you're collecting.
Right, but this is the conundrum we face.
Collection gets stories too.
Yeah, but
Right,
not
when
like
you
not
collect
like
without
leakage. You don't get.
informing users that you're. I mean, I can start naming.
Oh yeah, we can. But plaintiffs' attorneys don't come after you until you get data breach laws going in.
No, but it'll get you a news story.
Yeah, I still say.
We do. I mean, we did the PATH case about
That's
collecting
true.
it.
Path. Okay, we got Path, but
We'll say it.
there are a million apps, and of those, I mean, this is a problem. I have to recognize Lorraine Ackerman is here from Moms with Apps, and one of our earliest discussions, that's a developer group. If you guys are interested in doing educational apps, Lorraine is here, and they grew to about 1,500 developers doing educational apps for kids. And I will tell this story. Lorraine will probably be mad at me. We were on a call with a big group of ed developers about going in to meet with the FTC. And several of the developers talked just like you, and they said, actually, don't use our name, don't talk about us, we want to hide. And what I said on the call was, Lorraine, I said, no, be in front and be upfront about it, because that's more likely to get some understanding from the FTC, and it worked. We went in and spent, 3-4 hours with them in that meeting? Because the problem is, Jonathan, even at that level, where these people really cared about privacy, part of their response was, don't look at me, 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 and no one will see me, and I'll hide in a million apps. And the problem is that it's just going to kill you on the long haul. We all know we build apps like Legos, right? We stack it together. And I agree with you. I want to use Heroku. I mean, let's face it, Amazon knows more stuff about us than... We were joking about that the other day at a meeting from a social standpoint. Google knows what you search for. Facebook knows what you like. Amazon knows what you buy and when you bought it. They know that they can show you an ad at midnight because you're more likely to make an impulse purchase when you're online surfing than you do at, say, 2 o'clock when the kids are up. They know what kind of items you buy at different times. And I don't think that's bad, but, there's a huge amount of information. And if your app is part of the flow that goes to Amazon and you don't report it, then Travis, with, the power of the AG or 49 other states, or Laura could come visiting.
Can I ask a kind of a sidelong question? How does this privacy, and I will comply.
You do have a Fifth Amendment right against self-incrimination.
But how does this go along? And this is education. And kind of something as a petulant child, but how does this go along with the Obama's administration statement saying, you know what, people who carry a cell phone have no expectation of privacy, and so therefore we actually don't need a warrant to get this information.
This is what we're No. This is me taking my ACT hat off. We work with EFF
I mean,
on
we all have
ECPA
to talk
reform.
about this as like,
It might be if I've had-
you know what I mean? But this is like not, yeah.
Posing a question, not
It's-
challenging the
Right,
panel. Just posing-
right.
yeah.
Amen.
It's not a challenge. I'm genuinely curious because if I'm code, what? Huh? So, okay, yeah, I'll have a privacy policy. What? You don't need a warrant to actually figure out where I am all the time? Weird.
I mean, that is a whole other very, very important and very sophisticated debate that I don't know if it's really for our.
No, it's not, no, I'll jump in this way.
Yeah.
It's not something we're going to go into right now, but I think what Jonathan's just trying to highlight, and actually one of my notes from the conversation is, what we're talking about is we have a conflict here. We have a conflict between innovation, like the IP stack, as it were, and innovation, and what we're trying to seek maybe from a social, legal level. And I think that's what we're really highlighting and discussing. And so all I took Jonathan's point was, not necessarily, we're not going to go down that rabbit hole, but to say, hey, look, this is not an easy issue. This is something that's very complicated, and it goes beyond even the scope of this panel. It touches, because we're almost hearing two different messages. And right or wrong, or where everyone falls, isn't really the point. At the moment, the point is to just identify the conflict in the conversation. And so actually, I have one last question for Parker in this case. So is PII dead? Is the notion of it dead? I mean, we've talked about the IP stack. We've talked about, regulators trying to push through that stack, but still trying to balance innovation, but I'm not sure how to pull that off. But from a consumer standpoint, should we just let it go?
Well, I think if PII is dead, long live PII. I mean, this is, yeah, I think that what happened is it did come out the other side, and now if I were developing an app, I would be very hesitant to call anything categorically not PII. And part of that is because of research that's coming out that is I mean, this isn't like tinfoil hat things. This is people are able to, when you've got big enough data, you can personally identify people with any number of things. And so there's just a report the other day that if you have location history for somebody, that can be 95% personally identifiable. And that's, you may think, well, no, it's anonymously collected. We just know which phone was wandering through the store. But that is, even anonymously, that's PII. And of course, there have been bigger stories over the years of search history, whether that's that being de-anonymized. And so I don't think PII is dead, but I think that it's something that it looks a lot different from maybe the first time it was defined, because it really is a category that includes a lot of things. And really, maybe the identifiable part needs to just be assumed at this point, that it's whatever the user inputs or the user's device inputs, that's I mean, I would be hesitant to call anything in that category definitely not PII.
By the way, we didn't ever define PII. I realize we're using acronym. Personally identifiable information.
Yeah, we did.
Oh, good.
That was in the beginning.
Still, let's say it again.
Yeah, because we were just acronyming like crazy there.
So, but let's actually, you touched upon actually where I want to go with this, and that's the anonymized information. And actually, earlier you talked about collection point. One of the challenges we found is holding aside data leakage as an issue or data theft. Sometimes companies are just releasing data and they're saying, oh, it's clean, right? It's clean, go ahead. This is Netflix. This is the issue they ran into. This is AOL. They both paid the legitimate price, you could argue, on this by releasing what they thought was anonymized data. But it turned out that it wasn't, and not just because of the new information that you're talking about, but with the 95% identification based off of mobile device. So just very, kind of going back down to a brass tacks a little bit here, and especially for the developer on the table, but also for the regulators here as well. Should developers ever release cleaned data? I mean, should they, should that just be part of these kind of general rules of protecting information? We're saying, you know what, we're just never going to release anonymized data absent, certain government issues. Hold that to the side.
I like data, please give it to me.
Okay.
I mean, I won't answer the normative question. I certainly see the benefits of releasing data sets, both when they're released by the government and when they're released by non-government entities. The one thing I will highlight on the data leakage side, because we haven't really spoken about it, and it's in this country, it's pretty much unique to states, is that there are data breach laws in the vast majority of states in the country. About 47 of them, I think it might be 44, have data breach laws. And what that means is that if you have a breach of personally identifiable information, that you as the company are responsible for notifying the consumers that their personal data has been accessed by someone without authorization. In California, we actually have a new law that requires any company that has personally identifiable information of Californians, which has a breach involving more than 500 Californians, to report it to the Attorney General's office. And so I highlight this for you because you have to know that when we're talking about privacy policies, we're really talking about the front end, about collection and transparency in collection. But there is a back end. And that's what happens when the personal data that you've collected is accessed or divulged or otherwise obtained by someone without authorization. And there's a different legal regime that applies to that. So you need to know about that because that's, as Morgan highlighted, that's actually when most lawsuits start. And it's not just the regulators that one has to fear then, which actually is much more likely, I would say, in the case of a breach, is a lawsuit from a plaintiff's attorney. And you almost see it every single time we see one of these. We see multiple lawsuits filed by plaintiffs' attorneys across the country. That, just from a dollars and cents standpoint, will eat into your budget, plain and simple. Apart from the publicity, if there are settlements, even without settlements, litigation costs are very expensive. And so you have a real incentive on the front end to try to avoid that by ensuring that you've got all the appropriate data protection policies in place, as well as ensuring that your privacy practices are up to snuff.
So, this would be like any other practice by a company. We would look and say, when they released this, this data set, was it consistent with what they had told consumers they would do? And, if they were trying to be consistent with what they told consumers they would do, they said, we're going to release data to our partners who are going to use it for research purposes. Did they have reasonable, Travis raised that this could be looked at in a breach framework, and I think it could. We look to see if companies have reasonable efforts to make sure that they honor their privacy promises. So if you have a breach, if something happens to your data that's not what you intended or what you expected, we don't always say you automatically deceived consumers because you said this wouldn't happen. We look to see if you had reasonable steps to try to uphold your promises. So those are the things, that's how we kind of begin to look at it.
And what Laura highlights is something that I had not mentioned earlier, but someone else raised a little while ago, which is why shouldn't you just go to a random website whose privacy policy you like, just copy it and paste it and make it your own privacy policy? It's because the government and the public hold you responsible for what you say in your privacy policy. And if you make representations in that policy that you don't adhere to, then ultimately those will be, used, frankly, against you. It also means that even when you do diligently do it on the front end and write the appropriate privacy policy, that you want to make sure that as your business model changes, you update your privacy policy accordingly so that it reflects accurately what your current practices are and not just what your past practices are.
Can I be a problem child?
Yes.
If I have a privacy policy that just says all your data belong to me, am I good?
Yes. From this side of the table.
So,
yes.
I hate to be like a broken record because you're so like colorful and you say novel things and I keep saying the same thing.
We would look at this from the perspective of a reasonable consumer. What would a reasonable consumer think that meant? And we'd look at how did you say it. If it's buried in small point font under a capital heading and it looks like regular privacy language, would we think that's conspicuous enough to tell the user they lost all control of their data? Probably not. We've had a case called Sears where we said, yes, you said you'd be tracking consumers and looking at all of their account numbers and the contents of their communication, but you buried that disclosure, and that's not good enough. So, it would be like anything else. If you made it really prominent, if the name of your app was We Steal Data, and you said that on all the screens where you interact with consumers,
we're on it.
Maybe
now.
there.
And I would actually say that even if you did that, you'd still violate multiple laws, and I'll start listing them. The Children's Online Privacy Protection Act.
Well, you'd have to
You
have actual
cannot
knowledge.
collect data from someone under the age of 13
Unless
without
you have actual
verifiable
If you have
parental consent.
actual knowledge.
Actual knowledge.
you're directed
Careful,
to kids.
careful now.
We don't have to, yeah.
If he's saying all data you give me, and they give him the age, and he collects it, it's still good.
I'll
If
give
you're
you an
collecting
example.
health information, medical information in the course of that, you're going to get hit by HIPAA, the Health Information Privacy Protection Act. If you want to talk about the California Online Privacy Protection Act, it actually prescribes in certain categories that you have to state the kinds of personally identifiable information you collect. So you can't just have one sentence. You have to actually state in there, I collect geolocation, I collect name, I collect your age. So I actually think that it wouldn't be sufficient and that you'd be in real jeopardy by not being more forthcoming in your privacy practice. Now you can get away largely with saying, here's everything I collect, except from kids without verifiable parental consent, and I don't collect health information, and then you might be able to get to the statement that you want to say, which is, it's all mine.
No, I'm trying to look at the realities of being a developer, and I'm being funny, but no, kind of seriously. And you guys are being very, very patient, but how many people kind of think like I do that actually develop apps on a regular basis? I suspect a number of people, most of my friends would be, and honestly, like, you scare me because I'm going to violate digital privacy laws inadvertently. Because when you tell me that if there is a leak on my server and my data is released, my assumption as a developer is that no server is secure. I just assumed that security is kind of...
And that's
taken into
consistent with what I said. We look to see if what you did was reasonable. We don't look solely at the result. Like, you can have a breach and you did fine. You didn't do anything wrong. Or you can have a breach where it turns out your practices really stink and you weren't even doing the reasonable, low-cost things that everybody else in your industry is doing. In that case, you might be in grave trouble.
So we're actually running out of time, and I hate to stop it right now. But I want to stop on the word reasonable. I want to keep us on that plane. And I also want to give the audience a chance to ask any questions if they have any. We have a few minutes.
Sure you do.
And we do have a few questions. So what I'll do is I'll call you. We'll do about maybe 10 minutes at most of questions. We'll start with you. Please say your name and whom you're with, and then go ahead and ask your question.
Hastings, and we've been talking about the plaintiff's attorneys, and I noticed there are no plaintiff's attorneys on this board. I mean, yes, we have the government regulator side, and I think it's great that you guys are having a dialogue here, but what's happening to try and incorporate the plaintiff's attorneys into this? And the thing is, usually the plaintiff's attorneys are representing a client, at least in theory, so there are consumers in the back end who are concerned about this too. So how do you incorporate them into all of this? Because as great as it is to have the FTC and the DOJ talking about it, you guys are still going to see
Actually, that's not true. There's a problem that exists in the privacy space, and it's a pretty big one. It's called actual harm. It's the harm theory problem. The reason that you don't see a lot of plaintiffs' attorneys working on this is because, frankly, and a lot of developers, this is a problem we have from a developer community perspective, is where's the harm, right? So if it's not physical or monetary, or there's no something that you can seek damages for, it's pretty hard to argue that the fact that I was able to give you an advertisement that targets you, unknowingly collected information that allows you to know that you like red cars rather than green cars, it's hard to go before a judge and argue a harms theory around this. So it isn't as straightforward as you think, well, we've just opened ourselves up. Now, unfair and deceptive trade practices under mini FTC and FTC authority, that's different. But harms theory is different, and I think Christine is in the back there, Gagne is back there as well. So, there are others you can talk at length about harms theory, but we haven't talked about it at the table at all.
And one thing I would add is there's a difference between actually winning the case and actually litigating the case.
Yep.
And I think there are, Morgan's point is taken about actual success at the end of the day. But the fact is, there are a number of cases that are filed, and when they are litigated, that's expensive. And it will cost a lot of money. And if it happens in multiple jurisdictions, because you're doing business all over the country, that is going to cost you a ton of money, even if you prevail at the end of the day in every single one.
Yep, I agree.
There's another question I thought inside was right there. So, you first. And then you. Yep, see.
I kind of have a statement because there's a disconnect. probably worked with 1,200 different developers. And I've also.
Do you mind saying your name? Sorry.
Bill Holtman.
Uh-huh. Hi.
And I'm in product management consulting, so I've actually had my name on subpoenas because we're the legal responsible person. But most of the developers I've worked with, they have a no harm mentality. I mean, when you tell them, when you find a really good piece of code, you're going to copy it because it's good. If you find a really good policy, you're going to copy it because it's good. That's where you're going to start with. And I think you guys, regulators, have kind of missed your real message, your real underlying message of who you represent, and that's the consumers. In situations where I was dealing with people who, and I was also in wireless networks, people we put in network traces, and then we found malicious people using it to trace where their ex-wife was with their kids. I've had developers 30 years old sitting there in their cubicle crying because they just realized they gave somebody a tool that they didn't intend, but there is malicious intent of people out there.
Right.
And in the 12 minutes, I have not one developer I've worked with that has that malicious mentality. They're off trying to do good, they're off trying to help people. So most of the time when something happens, it's a total surprise to them. And where you are is you're trying to protect children, you're trying to protect the consumers, and you need to start from that point. Because the California Attorney General, in his first statement, I was ready to leave California and go code anywhere and not let anybody, any citizen in California, ever touch my code.
Yeah.
And the real thing is, you want the developer community to start using tools and applications providers that they can build on. We're very used in technology to have layers. The whole internet is built on layers. And different layers provide different things. So what we want you to do is work with the tool providers, not the frickin' platform people like Google and those guys, to give the developers something to work within because they do not want to harm.
You mean like better code sources and things like that?
Of, encrypting all the data, you give them a hint of what to do, you give them tools that will do that, then you're going to get somewhere. But this threats and, we're going to sue you and we're going to shut you down, that's not going to help anybody because any one of these developers who's ever had something, their code misused, it's a deep emotional impact on them. They do not want to harm their consumers.
Okay, I'm good. Do you have a quick response?
So my question is,
Well, I want to make sure I understand. I hear what you're saying, and I absolutely believe you that people do not intend to do harm when they build cool products for users.
And there's no perfect software.
Yeah. I mean, I do see some common ground in what we're saying. You find cool code and you want to use it, and we think that's awesome. But again, we are urging that you would investigate and kind of be familiar with what that code does, have a little bit of time spent to figuring out what that does. And we've encouraged app developers and others to participate in associations, like associations and community groups where you share information like that. We recognize, you're not one of the top 100 apps that has like a team of lawyers ready to write your privacy policy and vet it for you for weeks at a time, but you need to be in communities if you're using these commonly available tools where you can share information about. If you don't have the resources to figure that out on your own, you need to get with some other people and work on figuring that out. But it's absolutely, I agree with you, a huge problem that there aren't, more privacy-friendly tools out there and available. And I know some people are working on that. I'm happy to.
Yeah.
Yeah. I mean,
I want to give the FTC some credit here. That's happening. In fact, actually, hopefully in a couple of months, I'm looking at somebody else who's involved in it. In very short order, we're actually going to have a set of tools that are out dealing specifically on the COPPA side, including hopefully some COPPA compliant analytics and some other tools exactly like that. So to credit to both the AG's office and theirs, you talk about the big names, but the fact is that we've been working with analytics companies. So she's talking about us. When she talks about associations, talking about people like me who are trying to interface and do our penance by backing you guys up in these discussions. And the tools are coming. We are doing a better job. But I'd also point out, look at the tools that exist. Jim Brock from Privacy Choice has an incredibly good proxy server that you can just basically download an app, run it against it, and do some code checking. So they exist. You're completely right. I feel you. This is every developer conference I've been at. That's the conversation I have. But we're getting there. And so help us. Help by joining in. Help us do a better job on UI. If you've got 1,200 developers, share one of them. Because we're going to need more help on the UI UX side of this to get it across the border. And if you've got 1,200, I think you can work with 1,199
Yeah.
and spare
Yeah.
one of them.
Yeah,
So they are doing that, and I know that it's hard for them to tout their own horn. They're trying. The report that Travis talked about, that Joan McNabb and he worked on, we went through it on a language basis, on how do we change the word so it's more appropriate for users. With the Federal Trade Commission, same thing. There are 22, the document that they put out specifically called out the roles that platforms, tools makers, app makers have a requirement to. So I know you guys are the stick, but you are trying. I got to say that. You are trying. So.
Well, and consumers can't pay the price. I mean, you can't say, I've got this really cool product and I'm going to put it out there, but I don't have the time to investigate it. And, you know, consumers are going to bear the risk associated with that.
Well, the place to start is if you do these standard practices using these recommended tools, then the developer's not going to hurt us.
I'm going to jump in for just a second here because what I want to do is one last question, move off this, and I will remind you that we have lunch coming, and you can talk to the panel afterwards as well, so this isn't to kick anyone off. So what I'd like to do is one last question, sir, in the back in the blue in the hat, I think, and then that's it.
Jerome Strack, Bitman Software. This is just a very fascinating, universal sort of synchronicity thing happening here because I just developed some code for NASA that we're looking at sort of motivating you to understand why we're funding NASA, as well as I was just approached last week by an IT specialist in the education system here in California. So it's so interesting that I'm hearing this discussion going on because I had no idea as a developer. It's funny to watch CNN talk about the 14-year-old app developer who now is being confronted by 15-year-old being put in prison because they violated somebody's rights, right? Like, this is terrifying to me, and I had no idea that this was at this level. So it's fascinating what you're talking about. It's terrifying all at the same time. I really don't have a question, I guess.
Well, yeah, it's okay. You should know NASA uses Privo as its third-party provider for verifiable parental consent. So NASA actually already has to work with under 13 kids. And the last part of it, again, you heard part of the ability for us to do this event and to work with Charles on this. The platforms are willing to put some money into developer education. That's how I was able to arrive here and how we were able to put this together. That's right.
That's right. But what he's saying is flippant and also so serious that I don't know that anybody's really getting. So we're talking about at the beginning where the AG said, I can, with a pen, cause your life to be hell. That's essentially what she was just saying. So I'm hearing that we want to be encouraged to develop, and at the same time, I'm standing here going, oh. Wow. That's all.
Yeah.
It's just wow.
Yeah, no, I'm being deadly serious, and the only thing that I would ask is please be gentle with me.
On that note.
Okay, so right before we wrap up, I'm just going to do 5 quick takeaways for myself, and I want to thank the panel. The first is that for all the developers out there and all the entrepreneurs out there, privacy does matter. And this conversation is going to continue to evolve no matter how scared you may have been by what people said or excited you may have been about challenges that were issued. This is going to continue to evolve as a discussion and to stay plugged in and to learn more. Second, be thoughtful. I like that, Parker. Start from the beginning. When you're doing the designs, you may not know everything, but even a little bit of reasonable action from the very beginning of development may go very far when you start to run into issues, whether you're talking about M&As later on or you're talking about running into the government for some maybe data leakage issue. Third, err on the side of being a consumer as well. I think Jonathan talked about that. So that's a little bit of the be unto others. And think about yourself as well. Think about what may creep you out. And if that creeps you out, you probably shouldn't do it. A little bit more, last kind of combined thing is more communication is still needed. I think that's something that we're seeing. What's great to see is that people are here. People are willing to talk and people are willing to converse. And that needs to keep going on. And please always find me if you want to do that. That's how we see ourselves as a convener for these conversations. And finally, a little bit of the conflict is in the mental framework here. I'm going to call it the IP stack versus the legal stack. And that is, there's a different framework. It doesn't mean one is wrong or one is right. They're both realities that we need to work with, and we need to start figuring out ways that they can communicate better and that we can start to merge those two. So with that said, again, there is food back there. Go check out the website for links for more information, including the AG's panel. And, we have a speaker coming. Oh, the speaker's coming up. Sarah, oh, she's ready. Okay, excuse me. But then I'd like to thank the panel for coming today and spending this time with us. It was a great conversation. Thank you so much. I apologize.
Thank you very much. I wanted to give you the URL for the website where all those links that were talked about are. It's innovation.uchastings.edu. And that's where you can find all the links from the FTC and other of the speakers that you'll hear today.